Journal of Department of Legal Studies, with research interest primarily in criminal law and constitutional law. On that note, I warmly welcome Mr. Rudra Roshan sir to conduct today's session on Mastering Mood for Advocacy organized by ClassMax. Over to you, sir.
Good evening, everyone, and thank you so much for your introduction from the. So, further ado, today, first tell me if I'm visible to everyone. So, just a thumbs up can be okay.
Yes,
So,
sir.
I believe it is working. Perfect. So, as I can see that there are a lot of people who all are the moot enthusiasts, I can say. So, in a legal law journey, that becomes a very much fundamental, very much important for us, this particular moot competitions, which I would say. And some of us might be the new for that matter in this particular journey, and some of us might have participated in the competition earlier. But taking the middle path for that matter, and taking the split of both the sections or the sectors of the people who might have the experience prior or who might not be having the prior experience for that matter. So in this session, I would like to give the my expertise or throw some light upon this topic all around the moot code. How we prepare for it, what is a moot code for that matter, how you try to find out the opportunities which are available to you, be it the moot code competition or any other competitions for which you as a legal student or a law student are eligible to take part in. So let us first start with a basic question that what moot court is, or how is it different from the real life court, or how is it different from a trial advocacy that we see. So whenever we look for the opportunities from the perspective of a student, I would say, we are given by the BCI guidelines as well. If you will go through that, you will understand that this BCI guideline provides us to take up moot court competitions, to take up the court visit for that matter. And on that very note, there are many and lot many this colleges all around India who have inculcated this particular guideline into their curriculum, into their syllabus for that matter. So you will see that in the last years or in the final year for that matter of your law journey, be it in the LLM, be it in the LLB, that is the 3-year degree, or be it the 5-year degree, that is for the integrated course of BA LLB. You would see in the final years of your career, the moot court becomes a part of your curriculum. So to start with, that what moot court is and how is it different from the real life courts, I would like to say that it is nothing but a stimulated form of a particular real life court scenario. It gives you a touch of the experience, I would say, the first-hand experience that how the court functions, what are the peripheries, and how the legal criminal justice system revolves around that particular court, you can say, or that structure for that matter. Because I would like to tell you that the practicality and the theoretical aspect differs a lot. They are, although the two sides of a same coin. That reminds me of one of the saying by the famous jurist and the judge of the Supreme Court as well. That is the Justice Krishna Iyer, Justice V.R. Krishna Iyer, sir. He says that a lawyer's worth is measured not by what he knows, meaning thereby a worth of a lawyer cannot be measured by what he knows and what he has studied throughout his legal career for that matter, be it in the colleges or be it out of the college for that matter in the legal field. But he stresses on the point that the worth of a lawyer is measured by what he applies and how he applies what he knows. Meaning thereby, just to simplify this particular point and the saying of Justice V.R. Krishna Iyer, I would say that application and the knowledge of law are two sides of the same coin. In this moot court competition, this application as well as the knowledge of the law plays a very big important role for that matter to enhance your legal understanding on a particular point of law, as well as to increase your vocal capacity for that matter, your public speaking. There are a lot many, you can say, the positive aspects of a moot court, which I can give you in numbers. So there are a lot many, starting from your self legal understanding for that matter, which it enhances definitely, because as you can see, like many of us in our legal career consider that law is nothing but nothing less than a dead letter of law for that matter. So whenever you will open up your bare act for that matter, you will find that it is nothing but the black and the white letters. You won't find any, for that matter, figures or any other thing which brings up the interest in a particular student. And of course, it goes unsaid that it is different from any other, you can say, profession, be it the architecture, be it engineering, where you get the technical knowledge for that matter at every aspect of life. But here in the moot courts and here in this legal, for that matter, you can say curriculum or the legal structure, the legal, you can say BLLB or the LLB courses, you won't find much practical aspect until and unless you apply for these kinds of competitions, or until and unless you go for some, you can say, the internships for that matter, where you get the practical exposure. So, after saying that what moot court is, I would like to throw some light upon the aspect that how is it different from a trial advocacy. So, the word trial advocacy should, whenever is this word is spoken, it should remind us that it is a nothing but a function which happens in the lower courts for that matter, or the subordinate court, that is the sessions court. But when we talk about the moot court competitions or the moot court as a word, it should give you an impression that the cases are falling in the courts which are higher in the hierarchy. That is the high courts, or be it the Supreme Court for that matter. Or sometimes you would also find that these kinds of competitions also involves the international courts. That is the ICJ, as we call it, the International Court of Justice, which functions on the ICJ principles and the statute for that matter, and all the other laws of international perspective or the international application. But when we talk about this moot court competitions, it is restricted to the higher courts, that is High Court or the Supreme Court for that matter. Again, stressing upon that point of view, I would like to again elaborate on that aspect by saying that when we go to a court, we only go with certain issues, only and only when we have certain kinds of, we can say, dispute for that matter, wherein two or the more than two parties are at dispute. That reminds me of one of the explanations which is given under the CPC. Most of you might not have studied yet, but just to make it more clear or simplify the aspect, it is the explanation 3 of the section 11, which says that issue is nothing but where the consensus differs, where one person suggests something and the other person does not accept it, does not accept the inference which is put on by the one party. That is where the issue arises. Meaning thereby, let me give you one example here. Let's say that there are two parties, Mr. A and Mr. B. Mr. A says that my name is Mr. A and I reside in this particular house, which is my house. So there are two possibilities, right? There is no gray area for that matter. There is only black or either white. Meaning thereby, the other person, let's name that other person as Mr. B. He may suggest that, and he may, you can say, argue that the points which are asserted by Mr. A, that his name is Mr. A and the property in which he is living belongs to him, either belongs to him or not belongs to him. So that's where the issue arises. That's where this particular, you can say, the legal, for that matter, dispute journey starts or begins. So when we approach these courts, we approach with certain issues. And that's when we have to bring up the arguments, we have to bring up the counter arguments for that matter. And that's how these moot courts, these real life court scenarios works. And whichever party has more convincing points in his or her favor, that party wins. So there are a lot many things in this moot court that we will cover in this particular webinar for that matter, that how to frame the memorial, what all should be required for you to learn from that very perspective of winning. So having said that, the difference between the moot court and the mock trials, let us now talk about where do you find these kinds of opportunity. So as you must have got the introduction and the you can say a gist of the workings, how the ClassMax also works. So I would like to congratulate the whole team for that matter. They are, as they are supporting the legal students, and also the every other person who is related by one or the other means with the profession of law. So I would like to say that the students might find all kinds of opportunities which are available to them, and all those opportunities for which they are eligible. They are eligible to take part in these kinds of competitions, and they can definitely go ahead with that. Apart from the ClassMax, there are many other, you can say, websites, the legal databases websites, such as the SCC Online, where there as well you can find the moot court competitions which are organized. You can also visit certain, you can say, websites of the colleges. There you can find the opportunities which are available for that time being. Apart from that, you can also visit this Loctopus website, and there are n number of websites where you can see. So there you find those opportunities, and that's how you move ahead with that. So having said that, um, let us now try to get the understanding that how do you prepare for a moot court? How you have to start this particular journey of applying what you know, and also to gather more and more information from the n number of sources which are available to you, be it the primary or be it the secondary sources. So again, as I have used these two words, the primary or the secondary sources, let me throw some light on that as well. So the word primary, it means that um, you do not have to do any extra for that matter to inculcate or to gather certain other knowledges. So where do you get this particular thing? So try to think that the books, the bare ass becomes your primary source of knowledge, where you do not have to do some extra effort to gain certain knowledge or some certain understanding upon a legal perspective or any kind of point where you have to. But when we talk about these secondary sources can be of n number. So, meaning thereby, there are many websites like the SCC Online, the Westlaw for that matter, the Manupatra, any other things where you can go and search about any kind of legal topic, and you can get whatever is available in this legal forum. Apart from, you can also visit the libraries, you can also refer the commentaries, you can also refer the legal journals for that matter. You can go and search for the legal law reports, which is there the Law Commission report. In the terms of Law Commission report, which is the nodal agency of the Home Ministry for that matter, they publish in time upon each and every law topic and the burning legal topics. So there you can find, so these all becomes, in a nutshell, we can say the secondary sources for that matter, where you can gain certain knowledges. So keeping that prime focus upon the question that how do we prepare for a moot court? So the very first point which comes to my mind to answer this question is by thinking, by mastering, and by organizing. Let me tell you that from very basic thing, that whenever a moot court competition is organized, the organizing committee, maybe it may be the colleges for the most of the times, or any kind of legal initiatives taken by any websites or so. So they organize it. What do? They frame a particular proposition. They frame a particular factual matrix, factual scenario in front of you in 2 or 3 pages or 4 pages, depending upon the rules and regulation of the organizing committee. Then many a times what they do is they put up those facts in such a scenario or in such a, you can say, they address those particular facts in such a way that there are certain legal loopholes left. Loophole left for you to argue upon. What do we call them? We call them those issues. And many a times you would find that the organizing committee, what do? They give you certain issues. They give you multiple issues, 3, 4 issues for that matter. And many a times you would also find, let me tell you, that there is no issue which has been given by the organizing committee, organizing, you can say colleges. They do not give that. So there are multiple moot court problems where you will not find any issues for that matter. So there you have to use your legal acumen, your legal understanding to understand that what all are the points which are in issue. So then starts the journey of a particular moot court competition. You read that particular proposition, the thumb rule which I have said, that thinking, mastering, and organizing for that matter. These 3 words plays a big role. Whenever you get a particular moot court proposition, the first and the very foremost thing which you are supposed to do is you have to think, meaning thereby you have to think that what all you know. Let us take an example that a moot court proposition is concerning a matter which is involving the fundamental right, that is the right to privacy. As we all know that in K.S. Swami judgment, it has been held to be a part of Article 21, that is right to life. So we can say that, let's take an example of the same, you can say the factual matrix, that the the area which is involved is the right to privacy as a fundamental right under Article 21, that is the right to life and the right to personal liberty for that matter. So the first thing you have to think that what all you know about it, whether the fundamental right, Article 21, you have to question yourself then, what all you know, meaning thereby whether this particular right can be availed against the state. So what is a state? Then you move on to Article 12. Then again, the another question which you should be putting to yourself on, or you can say introspecting, that what all you know. The second question would arise that whether this particular right of Article 21 is applicable or can be, you can say, availed through a person or a citizen, right? So, meaning thereby, a person, meaning thereby, any person, irrespective of his or her nationality. And when we use the word citizen, meaning thereby, the person belonging to a particular demographic structure, be it India, be it China, Pakistan, Bangladesh, anything. So these 2 words plays a big role. So lot many peripheral questions arises, which are some or the other way involved with that. So after thinking that what all you know, then you have to master. You have to master the facts, meaning thereby what all has been given to you in the moot proposition, as rightly said. You have to read it more than 3 or 5 times. Let me tell you, it will sound to you very basic that, why are we supposed to read 2 or 3 pages, which is suggesting the same thing again and again. But mind it that you might lose on, or you might miss out on certain, any you can say minutest of the details. So when you will read thoroughly multiple times, you will realize that you were missing out on something. So that's where mastering on fact suggests the, and you can say, comes out to be most important thing. And the third thumb rule, although it is not never the last thumb rule, you can say, is the organizing. In legal language and you can say legal structure, we use the word that is marshalling of evidences. So we'll not go into that, but let me tell you That marshalling, somehow you must have read in this transfer of property for that matter as well. So it means nothing but organizing, nothing but giving it a structure. So what you can do is, after reading the proposition multiple times, you can simply make two word documents. If you are very much comfortable with the online gadgets or the laptop or these things, so what you can do is you can make two separate Google document, giving the heading to a one document as the petitioner, or giving the you can say a heading to the other document as respondent or defendant for that matter. And then whenever you read again those facts in the continuity, what you do is you just organize those points which are favorable in the favor of one party, that is the petitioner, and that's also helps you in organizing those other points which are favorable to the respondent on the other hand. So that's where organizing plays a big role. Then comes preparing the notes. What you can do is, of course, like researching, we would come on to that how to research on a particular matter. But let us keep that for the coming, a few minutes that we will discuss about. So let us first tell you that we have to prepare notes for that matter. So after reading those propositions, what you will do, you will go online or you will sit in the library for that matter. You will sit with certain books, you will sit with certain commentaries, and that's when you will go and revise upon those points which you have already read, and you will also read certain new aspects which will broaden your horizon. But only reading is never going to help you. You have to prepare notes, because we tend to forget things until and unless it becomes a part of our, you can say, long-term memory, right? We must have understood, and we must have seen certain movies which talks about the short-term memory and the long-term memory. So, so that's why we have to memorize it. For that matter, we have to write it in the, you can say, a particular notes. हमें सारी की सारी चीजें एक नोट्स में भी लिखे हुए रखनी है, राइट? हमें सारी की सारी चीजें एक नोट्स में भी लिखते जाना है, जिससे कि हम जब आगे वी विल बी ट्राइंग टू प्रिपेयर फॉर दैट मैटर और आर्ग्यूमेंट्स, जब हम अपने यू कैन से अपने ओरल प्लीडिंग्स बनाएंगे, दैट्स व्हेन वी विल टेक द हेल्प ऑफ दोस पर्टिकुलर नोट्स व्हिच वी हैव प्रिपेयर्ड. And the last thumb, according to me, is establishing the principal submissions. When you are done with pointing it out and jotting down all those points which you have understood, जितनी भी चीजें आपने पढ़ी है, वो किसी भी सोर्स से हो सकता है, right? It can be from the book, it can be from a legal journal, or any report for that matter. कहीं से भी आप पढ़ते हैं, right? Which you have prepared a part of it, your own notes. Then starts the journey of, you can say, writing down your own submissions. What all are important? You might not feel that those points, few of the points are not that very important for you, right? आपने जब पढ़ने की कोशिश करी होगी तो उस टाइम पे आपने उसे लिख लिया अपने नोट्स में. But when you actually start writing your submission or actually start writing your memorial, then you find that these points are not very much, you can say, relevant. It is not very much helpful. That's when you eradicate, you remove, you let go those points. So from the very outset, these were the thumb rules that how we go ahead with the moot court, or you can making a memorial. So let us now talk about how do we prepare a memorial. किस तरीके से हम अपने memorial को बनाते हैं और memorial होता क्या है. जो 5 thumb rules हमने समझे, that is thinking, that is mastering, that is organizing, that is preparing, and last being the establishing the principal submissions for that matter. So these thumb rules will play a very big role, and you can say founding structure upon which the whole memorial you can say, rests. So what is this memorial? This question will definitely strike your mind. So whenever we move to a particular court, we find that the people argue, and people argue on the basis of their written submissions. That is, in the Civil Procedure Code, you will find under Order 8 for that matter. That is the written submission on the part of the this defendant for that matter. Although, taking this particular understanding and understanding from the legal perspective, there is Order 18 as well, which suggests you that जब हम कोर्ट जाते हैं और हमारे पास दोनों पार्टीज होते हैं, एक पार्टी जो प्लीड कर रहा होता है, जो एक तरीके से एग्रीव्ड होती है, एंड द अदर पार्टी जिस पे चार्जेस या जिस पे एलिगेशंस लगे हुए होते हैं, दोनों पार्टीज अपनी एक ओरल प्लीडिंग जो वो बोलने वाले हैं कोर्ट में, उसे वो रिटन वे में देते हैं. ऑल्दो रियल लाइफ कोर्ट्स में ये चीज यू कैन से इट डिफर्स, राइट, ये बहुत ही ज्यादा अलग होता है. But from the moot court competition, it is the memorial which suggests what all you are going to speak in the moot court competition. क्या आप बोलने वाले हैं, वो सारी चीजें आपकी मेमोरियल में ही रहती है, आप उससे आगे नहीं बढ़ सकते. Let me tell you here that in many competitions, first thing what you have to do is you have to adhere to the rules and the guidelines which are given by the organizing committee for that matter. They say that you are not supposed to utter anything further which is not beyond your you can say position, beyond your memorial for that matter. आप अपने मेमोरियल में आपने जितनी भी चीजें लिखी हैं उसके अलावा एक शब्द नहीं बोल सकते. Of course, they are the masters, and when they are framing up the rules, it will be the holy grail for that matter. Therefore, you have to adhere to that. Otherwise, you will end up losing marks on that. But of course, like यहाँ पे मैं एक चीज है और आपको बताऊंगा, and I will give you a mantra here. That, let me tell you, anything and everything is allowed in law if you have the proper permission for that. Please mark my word that if you have the permission, if you have taken the permission, or you can say a leave from the respected court जहाँ पे आप आर्ग्यू कर रहे हैं और उन्होंने परमिशन दे दी है आपको एक्स्ट्रा बोलने के लिए जो आपके मेमोरियल में लिखा हुआ नहीं भी है, वो भी आप बोल सकते हैं. That will definitely not be subject to losing some points for that matter. वो आपको वहां पे नहीं आपके पॉइंट्स काटे जाएंगे. बट ऑफ कोर्स जनरल रूल्स आर दैट जो आपने लिखा है आपको वही बोलना होता है. So to start with, I would tell you what is the structure of memorial. एक memorial के अंदर हमने क्या क्या चीजें रखनी है, what all we have to cover. This starts with the very first page, that is the you can say a cover page as you call it. आप उसे cover page बोलते हैं. So as we know that there are two parties in a particular dispute involved, that is the petitioner and the respondent for that matter. तो जब भी आप एक petitioner के behalf पे कोई भी memorial बना रहे हैं, so the cover page will always be in blue color. And on the other hand, the cover page of a particular respondent would be in red color. And you are not allowed to suggest or give any kind of impression जहाँ पे आपका नाम disclose हो और आपके टीम का, आपके कॉलेज का, ये किसी भी चीज का disclosure is strictly prohibited. That becomes a, you can say, fundamental rule. It does not differ. In every competition, it remains the same. Hence, you are provided with a particular team code. You are supposed to write a team code for that matter in the very cover page, which I suggested that for the plaintiff it remains blue and for defendant it remains the red. So what you can say a tail question to this particular suggestion might be that हमें क्या-क्या चीजें लिखनी है उस cover page में. So let me tell you that apart from the team code, you are supposed to write the name of the competition, कौन से year में ये competition हो रहा है, क्या केस का टाइटल है, लेट्स से मिस्टर ए वर्सेस मिस्टर बी हो रहा है, जो भी है, राइट, वट एवर दी फिक्टिशियस नेम, जो भी एक नकली नेम आपको दिया जा रहा है वो आपको वहां पे लिखना होता है. And then at the very footnote of that cover page, that you can say footer as you call it in the MS Office language, वहां पे आपको लिखना होता है that on behalf of which party this particular memorial is being presented, be it the petitioner, be it respondent or anything. So moving ahead, when we are done with this particular cover page, the very second thing is the list of abbreviations. Why this abbreviations? We all know that abbreviation is nothing but a short form. Let's say advocate, right? ADVOCAT is the full word for that. But the short form is ADV. So how will you able to make this particular point understand, right, to the person who is not at all, you can say, well versed with any kind of law, or वो लॉ के बारे में जो इंसान जानता ही नहीं है वो आप उसे कैसे बताएंगे? That again reminds me of like one of the provisions of the law, that is the in Contract Act you must have read, that is consensus ad idem, agreeing on the same thing in the same sense, meaning thereby that when you try to focus on a particular aspect but the other party is not getting what you are saying, not getting the essence, so इसलिए हम ये list of abbreviations बनाते हैं that अगर let's say किसी एक थर्ड पर्सन ने वो मेमोरियल देखा और उन्होंने पाया दैट आपने कुछ कुछ ऐसे वर्ड्स लिखे हैं जो शॉर्ट में लिखा है, SC, SCC, AIR, you can say ETC, there are lot many abbreviations. तो वहां पे आप इस abbreviations के यूज करते हैं and in the list of abbreviation you give the full form of that. I hope it is clear. Then we'll move on to the third aspect where you are supposed to write the index of authorities. Let me tell you here that only suggesting the facts is not going to help you. आपको फैक्ट के साथ साथ उसे कोरबोरेट करने के लिए, उसे सब्सटैंशिएट करने के लिए और सिंपली सेइंग उसे सपोर्ट करने के लिए यू हैव टू बैकअप दोज एस्पेक्ट विद द लॉ. आपको लॉ के साथ उसे बताना होगा. And how do you do it? You do it with the help of the authorities. What are these authorities? These authorities are nothing but the cases. These authorities are nothing but some judicial precedents, be it the international, be it national, that I would definitely tell you again. Throw some light upon that. As you know, that India is a, you can say, a common law country. Of course, like it also has the civil law aspect, but let us stick with the one understanding that it is a common law country, which was being ruled once upon by the Britishers, and we follow this precedent as the guiding principles. When you will see Article 141 again of the Constitution, जो हमें बोलता है that किसी भी judgment जो सुप्रीम कोर्ट के द्वारा दी गई है, that becomes the law of the land. वो एक बाइंडिंग हो जाता है सारे के सारे कोर्ट्स पे, सारी की सारी जुडिशियल और क्वासी जुडिशियल अथॉरिटीज ऑफ इंडिया. तो ये लिस्ट ऑफ अथॉरिटीज में आप ये चीजें बात करते हैं, आप सारे केसेस के बारे में लिखते हैं. अगेन ये मुझे दिस पर्टिकुलर थिंग रिमाइंड्स मी ऑफ मल्टीपल क्वेश्चंस हियर. ये बिल्कुल आपके मन में क्वेरी हो सकती है दैट केसेस हमें कौन से लिखने होते हैं, कौन से केसेस साइट करने होते हैं, कितने केसेस साइट करने होते हैं, मल्टीपल एस्पेक्ट. सो लेट मी टेल यू. First, starting with the first question, that is how many कौन से केसेस लिखने होते हैं. So first, let me tell you that अगर कोई भी बेंच है, let us say the present matter for which you are going, let's say आप जिस moot court competition में जा रहे हैं उसमें डिवीजन बेंच, दैट इज 2 बेंच, 3 बेंच, 5 बेंच, जितनी भी बेंच की एक यू कैन से द स्ट्रक्चर ऑफ द जजेस हैं, उससे आप ज्यादा लेने की कोशिश करें. लेट्स से अ जजमेंट व्हिच हैज बीन गिवन बाय अ 5 जजेस बेंच, दैट इज द कॉन्स्टिट्यूशनल बेंच, उस केस को आप ले अपने कॉन्सोनेंस में, 7 judges bench, this Keshwananda Bharti that reminds me of, it was the 13 bench judgment, right? A bench which was comprised of 13 judges, as many as. So you can take those matters. Why I am saying that? Because अगर आप एक डिवीजन बेंच के पास जा रहे हैं और आप एक सिंगल बेंच का जजमेंट लेते हैं, that will not be binding, although it will have a persuasive effect. It will have an effect where the court will try to get what the other court had said, but it will not be binding. They will take the inference, but it will not never be binding. Again, you're not supposed to take the matters which are adjudicated by the subordinate courts. You are supposed to take up the matter as we have already discussed, और हमने ये समझा है that moot court competition either high court या supreme court में ही फाइल होता है. तो हमें सिर्फ और सिर्फ हाई कोर्ट्स के ही जजमेंट लेने चाहिए, जिससे कि उसका परसुएसिव इफेक्ट और बाइंडिंग इफेक्ट थोड़ा बढ़े. और ऑफ कोर्स अगर हम सुप्रीम कोर्ट के जजमेंट्स लेंगे और हायर बेंचेस के जजमेंट लेंगे तो उसका इफेक्ट और भी ज्यादा बाइंडिंग हो जाएगा, टेकिंग द you can say article 141 in reference of the constitution. Then you can say you can also take up the international cases. There are many you can say legal provisions. आप section 13 वगैरह में पढ़ेंगे CPC के, आपको समझ में आएगा that आप international cases भी ले सकते हैं. You will find it surprising that many of the countries of the South Africa region or South Africa continent for that matter, they take the help of, or you can say they cite Indian case laws. And that should definitely be a proud moment for each one of us that जो भी सुप्रीम कोर्ट के केसेस होते हैं उन्हें भी वो एक तरीके से अपने आर्गुमेंट्स में, अपने जजमेंट में वहां के जज ये साइड करते हैं. तो that is the, you can say a friendly term, you can say this harmony amongst the other countries. That's how we respect the other country. We respect the laws of the other country. And in doing so, we are also taking up the precedents. We are also taking up the decisions which are held in the other law or other country for that matter. तो हम international cases भी लेते हैं. जैसे आप अगर देखेंगे this विशाखा versus state of Rajasthan की केस, उसमें आप देखेंगे that many international cases, the CEDAW, that is the Convention upon the Elimination of the Discrimination Against Women. So ये सारी चीजें जो कन्वेंशंस थी उन सबको कॉन्सोनेंस में लिया गया. तो आप इंटरनेशनल केसेस भी साइट कर सकते हैं. देयर इज नो कंफ्यूजन टू दैट. यस, आप कर सकते हैं. अपार्ट फ्रॉम दैट, आप कौन कौन से लॉज को रेफर कर रहे हैं. लेट्स से आपने मेमोरियल के मोट प्रोपोजिशन को पढ़ा, फ्रैक्चरल मैट्रिक्स को पढ़ा, तो आपको ये समझ में आता है दैट इंडियन कॉन्स्टिट्यूशन इज अप्लाइड इन दैट. The BNS, that is Bharatiya Nyaya Adhiniyam and Sakshya Adhiniyam, BNSS, many other laws are also applicable in that. तो आपके लिस्ट और इंडेक्स ऑफ अथॉरिटीज में वो चीजें भी आएंगी सब हेडिंग्स के साथ, दैट कौन कौन से कानून आपके इस पर्टिकुलर मैटर में इन्वॉल्व हैं. इसके बाद आपने कौन कौन सी, जैसे हमने बात की सबसे पहले इन द वेरी फर्स्ट बिगिनिंग ऑफ the secondary sources, that is the commentary, that is the law journals, that is the law commission reports and many other reports. वो सारी चीजें भी आपकी इंडेक्स ऑफ अथॉरिटीज में आएंगी. कौन कौन से वेबसाइट्स को आपने रेफर किया है वो भी चीजें आपको ड्यूली देना पड़ेगा, अदरवाइज इट विल बी अ वायलेशन ऑफ द IPR. सो वो सारी चीजें आपको वहां पे इंडेक्स ऑफ अथॉरिटीज में लिखनी होती हैं. देन कम्स द statement of jurisdiction. In the statement of jurisdiction, you as a party are supposed to convince the court that you have a locus standi. Meaning thereby, let me simplify it for you, that by what authority you are approaching the court, which law gives you that particular right. I believe you must you all must have read in the law of tort for that matter. आपने सुना होगा that where there is right, there is remedy. सो मीनिंग देयर बाय, अगर आपको किसी भी लॉ में एक अधिकार दिया गया है, if a law bestows right upon you, it also has to give you the remedy to enforce those rights. That's why we have this, you can say, substantive and the procedural laws in our country, or be it any other country for that matter. So, um, so yes, of course, that becomes a part of the statement of jurisdiction. There, you have to convince the court that yes, this particular court has the jurisdiction. This court has to listen to the plea of the party and cannot refuse to do so. But for that matter, आप कैसे convince करेंगे? Again, another question arises from this. You can only do with the help of the case laws that इस तरीके के present matter जो आपके in hand है, वैसे ही सिमिलर मैटर्स में कोर्ट ने अपने कॉग्निजेंस यानी कि संज्ञान लिया था, वो आप साइट कर सकते हैं। कुछ लॉज का रेफरेंस दे सकते हैं, जैसे आर्टिकल 32, जैसे आर्टिकल 141 और सॉरी 142, राइट, बीट 136, जहां पे आप एसएलपी के तौर पे स्पेशल लीव पिटीशन के तौर पे सुप्रीम कोर्ट जाते हैं। अगर कोई एक हाई कोर्ट का मैटर है तो इट कैन बी आर्टिकल 226, या हाई कोर्ट या सुप्रीम कोर्ट के ओरिजिनल जुरिस्डिक्शंस भी हो सकते हैं। So it can be anything and everything. That again, the High Court and the Supreme Court being a constitutional court, you will find it in the Constitution, the answer to it. That हमारा statement of jurisdiction क्या रहने वाला है, या कौन से statute में रहने वाला है, that you are supposed to write it. Then comes the statement of facts. Again, let me tell you, statement of facts suggests an idea that जो आपको मोट प्रोपोजिशन में फैक्चुअल मैट्रिक्स मिली है, यू आर नॉट सपोज्ड टू रिप्रोड्यूस अगेन द सेम थिंग। आपको सेम चीजें फिर से दोहरानी नहीं है, आपको फिर से वो चीजें लिख नहीं देनी है, राइट? ऑफ कोर्स देन द होल आइडिया ऑफ हैविंग दिस स्टेटमेंट ऑफ फैक्ट्स would nullify. So in this statement of fact, you are supposed to talk about the summary of facts for that matter. आपने क्या समझा, आपने उस पॉइंट्स को किस तरीके से इनकैप्सुलेट किया, किस तरीके से आपने उसको एक पैराग्राफ वाइज में लिखा है. लेट मी टेल यू, इट शुड बी प्रेजेंटेबल, इट शुड बी इन सेंस दैट आपका मैक्सिमम अगर 3 से 4 पेजेस के प्रोपोजिशन है तो यू शुड बी एबल टू वाइंड इट अप इन 1 पेज और 1.5 पेज, 1.5, that is 1.5 page. Why I am saying this? It might differ from the proposition, one proposition to another proposition. It might differ. It doesn't become a guideline for that matter, which I am saying it right now. It might differ. So the only thing which is certain in law, let me tell you here, is the uncertainty. All right. So meaning thereby there is always a scope of improvement. So yes, moving ahead. In the statement of fact, you are supposed to write the facts in a concise form, but mind it that you are not supposed to leave out on certain facts which are unfavorable to you. जो आपके मदद में ना आए वैसे आप facts छोड़ दें, that should not be the idea. It will, it won't be coinciding with the professional ethics of a particular lawyer. Whatever the fact has been given, if it is important enough, you are supposed to write it. And how it, again, it will give you another question that raise another question in your mind that, sir, that how can we say that this fact is more important and this is not important? We are supposed to leave out on that. So the answer to this would be, again, reading it thoroughly. Multiple times when you will read a particular proposition, you will understand. आप ये समझ पाएंगे that कौन से फैक्ट indispensable बन जाते हैं. That meaning thereby, without which a proposition will not hold any water into it, right? अगर वो फैक्ट नहीं लिखा है आपने तो वो सारा का सारा फैक्ट ही डूब जाएगा. So that's what becomes most important thing and most important fact which you are not supposed to miss out on. Again, what you can do is, while writing the facts, you are supposed to, in the statement of fact, आपको ये paragraph wise में लिखना है. let's say 6-7 lines आपने एक पैराग्राफ को दिए और इस तरीके से आपने subsequent paragraphs बनाए. How you are supposed to make it? You are supposed to make those paragraphs on the basis of the legal issues involved. Let's say, let us take that same example which we took, that is the case put as Swami judgment, that is the privacy being part of Article 21. So, whether let's say that first issue of that particular proposition suggests that क्या आर्टिकल 21 का ये प्राइवेसी पार्ट है, whether the right to privacy forms a part of article 21 or not. Or the second issue might be that, let's say, in a particular proposition it is suggested that वहाँ की सरकार, कोई भी देश की सरकार ने क्या किया, that एक लॉ लेके आए और उन्होंने लोगों से उनके the simple thing, that is the linking of the Aadhaar and the PAN card, आप लोगों को जैसे पता होगा हमारे देश में भी हुआ. तो अब वैसा ही कुछ एक सिनेरियो अगर हमारे फैक्ट में लिखा हो दैट वहां की सरकार ने एक ऐसा लॉ बनाया जिसमें कि उनके प्राइवेट डेटाज, दैट इज द पर्सनल डेटाज को मांगा सरकार ने, एंड डिनाइंग दैट वुड बी इलीगल फॉर दैट मैटर. आपने अगर डिनाई किया दैट, देन यू विल गो टू जेल. अगर ऐसा कुछ सिनेरियो लिखा हुआ है और उसी से रिलेटेड हमारा सेकंड इश्यू है दैट वेदर दिस पर्टिकुलर लॉ इज कॉन्स्टिट्यूशनल इनफ और नॉट, राइट? सो you are supposed to write in the second paragraph, or not only the second but आगे की जितने भी paragraph या subsequent paragraph जो भी number का होगा, you are also supposed to touch on that. Meaning thereby आपके paragraphs at least resemble करेंगे जो issues में दिए हुए हैं. 4 issues हैं और 4 issues अलग अलग चीजों की बात कर रहे हैं. There your paragraphs of the statement of fact should be suggesting those things in that, I mean in totality. वो सारी चीजें वहां पे आपकी जिक्र होनी चाहिए. That is the whole idea. You're also supposed to, you can say, think upon the sub issues. All right. अब ये सब issues क्या हैं? जैसे issues दिए हुए हो सकते हैं या नहीं दिए हो सकते हैं, तो हमें अपने जो फैक्ट है उसको उसके सब issues के भी निर्भर पे उसके डिपेंड करके हमें वैसा लिखना होता है. Let's say we say that Article 19 is not absolute. We say that it is not unqualified, rather it is a qualified right for that matter. These fundamental rights or the freedoms, the 6 freedoms which is guaranteed under Article 19. So what are those? Article 19 clause 2, 3, 4, 5, 6. Those are nothing but a rider upon the rights which are being given under Article 19(1)(e). हमारा राइट जो है वो हमारा you can say is qualified, is you can say has certain exceptions to it. तो उससे रिलेटेड भी अगर कुछ फैक्ट दिए हुए हैं तो हमें उसको अपने सब इश्यूज के तौर पे जो हम आगे यूज कर सकते हैं, तो हमें अपने समरी ऑफ फैक्ट्स में, स्टेटमेंट ऑफ फैक्ट्स में उस तरीके से अपनी पैराग्राफिंग करनी है. मूविंग ऑन टू द अदर पॉइंट्स ऑफ द मेमोरियल, that is the issues raised. Meaning thereby, as we have already understood with the help of the explanation 3 which is given under section 11 of CPC, that issue, ये issue होता क्या है जो हमने अभी समझा, right? तो अगर कोई proposition में issues पहले से दिए हुए हैं, then you are supposed to reiterate, meaning thereby you are supposed to rewrite those things again in let's say 4 issues are there, so you are supposed to write it in 1, 2, 3, 4. So what all issues are there, you are supposed to write it. Just simply write it down. Or let's say the competition has given you the liberty, उसके rules and regulations में कोई एक liberty दी हुई है that you can frame some additional 1 or 2 issues out of your own will or own you can say legal acumen. आपकी खुद की समझ से आप 1-2 इश्यूज बना सकते हैं, then it totally depends upon your discretion that आप extra सब इश्यूज भी बना लें. It is the discretion, all right? There is no rule as such. So, okay, moving ahead, when you have written those issues, then you are supposed to write about the summary of arguments. What are those? Let's say there are 2 issues. issue 1 and issue 2. In the summary of arguments, you are supposed to write again that issue, that is issue A, and you have to write a particular paragraph summing up what all is there in your argument advanced. That आपको ये एक आइडिया देगा दैट जो जज पढ़ेंगे उस चीजों को या सामने की पार्टी आपकी वो मेमोरियल पढ़ेगी तो उसे ये आइडिया मिलेगा दैट हम क्या प्लीड कर रहे हैं, व्हाट एग्जैक्टली यू आर आस्किंग फ्रॉम द कोर्ट. लेट्स से आर्टिकल 21 का पार्ट प्राइवेसी है या नहीं है. So in that summary of argument, you are supposed to write or some your submissions in one particular paragraph saying that yes, it forms the part, or no, it does not form the part. Also, you're not supposed to only write about yes or no, but you have to substantiate it with the help of a single case law or a single law for that matter, जो आपने एक वहाँ पे एक paragraph में you have fulfilled the need. That's what you have to write in the summary of argument. That will give the reader an idea that what all they are going to find in the further upcoming part of the memorial. Yes. I guess we have a doubt from Ananya. So yes, please, you can unmute and ask.
Sir, how many pages do we have to make for arguments advanced? Like
Okay.
minimum number of pages?
All right. So, okay, that's a very good question here. So moving ahead with that, I mean, that definitely I will take care and answer that when we will be talking about the argument adverse that we are definitely coming on to. So, but yes, appreciate it. So after this summary of argument, we are supposed to move on to our main pleading. We call this particular pleading as the arguments advanced, as rightly suggested. So there is, let me again tell you that there is no standard format that it should be in this many pages or that many pages. Again, you have to stick to the rules and regulations what all the organizing committee or the you can say the college has given to you or asked to you. Many a times you would find that the mention in the rule book that you are not supposed to exceed, let's say, 30 pages, 40 pages in terms of the memorial. Otherwise, you will end up writing a particular whole thesis on that. Right. So there you are supposed to, let's say there are 30 or 40 pages guardrail which has been given to you by the organizing committee. And you have this 3 issues to deal with. So it is advised, let's say in one issues you have given 4 pages, or let's say you can say 7 pages for that matter, right? So you have to dare do justice to it, to the other issues. So your other issues should also be in the terms of, let's say, 7, 8 pages or 6 pages. You should not be leaving one issue with 10 pages and the other issue with only 2 pages for that matter, right? So you have to take a balanced approach. Why I'm saying so? Because there are also marks which are based upon the best memorial. आपके एक कंपटीशन में बेस्ट मेमोरियल का भी एक प्राइस होता है, राइट? सो वो आपको ग्रैब करने के लिए अपनी मेमोरियल की स्ट्रक्चर भी अच्छी बनानी होती है. वी विल ऑल्सो टॉक अबाउट दैट. हमने एक मेमोरियल तो बना लिया, कैसे अच्छा बनाएंगे, वी विल बी टॉकिंग अबाउट दैट एज वेल. सो हमें एक बैलेंस्ड अप्रोच लेना है. लेट्स से वी आर 30 पेजेस गिवन, so let's say 9-10 pages, 8-9 pages, or like that. You have to bifurcate amongst the issues for that matter. Again, you are not supposed to beat around the bush. कुछ भी आपको नहीं बोलते जाना है. You are supposed to back it up. That we'll talk about in the argument advance. हमें क्या लिखना होता है. All right. So you are supposed to back it up. Whatever you are suggesting, inferring for that matter, वो आपको उसको back करना होता है law से, back करना होता है precedent से, ये सारी चीजों से, अपनी index of authorities में जो चीजें आपने लिखी हैं उससे. So starting with that, what all you are supposed to and how you are supposed to write the arguments advanced. There are again 3 thumb rules for that. The very first thing is that आपको जो भी उस फैक्ट में उस पर्टिकुलर इशू से रिलेटेड चीजें मिली हैं, राइट, वो आप फर्स्ट पैराग्राफ में लिखते हैं. द सेकेंड थिंग इज दैट आपके फेवर में जो भी अथॉरिटीज आ रही हैं, लेट्स से be it you can say cases, be it you can say the jurist's opinion or international cases, commentary, anything which is said by some legal illuminary for that matter, किसी ने बोला है ऐसा, जो आप अपना कोट कर रहे हैं आर्ग्यूमेंट्स में, तो सेकंड पैराग्राफ आपकी वो चीजें होनी चाहिए जो ऊपर के लिखे फैक्ट को सब्सटैंशिएट करे एंड आपको एक टर्निंग पॉइंट दे टू सजेस्ट द कोर्ट दैट इट इज in our favor, simply. And the third paragraph of that very submission should be summing it up that how those authorities which you have cited in the second paragraph supports this particular thing. And if it supports, then that's why we are praying from this particular court for certain other reliefs. I hope everybody understands this, right? पहला पैराग्राफ आपका हमेशा फैक्ट सजेस्ट करेगा, दूसरा पैराग्राफ आपका हमेशा अथॉरिटी सजेस्ट करेगा, और तीसरी पैराग्राफ आपकी हर एक पॉइंट की ये सजेस्ट करेगी दैट हाउ दीज अथॉरिटीज आर रिलेटेड टू इट. That reminds me of one more thing here, that in the very first paragraph when you are writing the facts, you should not be only writing that okay fine Mr. A has done this or did that, whatever has been written, आपको सिर्फ लिख नहीं देना है. Try to write it in a paragraph, try to write it in you can say brackets, that where in the proposition you have found this particular fact which you are writing in the first paragraph. ये proposition के कौन से paragraph के कौन से line में लिखा हुआ है, ये भी अगर आप रख देते हैं अपने arguments में, जब आप memorial बना रहे हैं उसमें लिख रहे हैं, that will definitely put a strong impression, let me tell you, in front of the judges or in front of the people, that yes, your memorial is different from the other. All right, meaning thereby you are giving the due credit to each and everything. You are not playing with the facts. That's the impression which will give in the mind of the readers. Again, while particular framing of this particular argument advanced, we are supposed to use the deductive method. मीनिंग देयर बाय आप एक जनरल अंडरस्टैंडिंग से आप एक स्पेसिफिक अंडरस्टैंडिंग की तरफ बढ़ते हैं. जस्ट अ मिनट, वी हैव टू पुट इट ऑन चार्ज. So yes, let me continue further here, that you are supposed to bring on your particular submissions in a deductive format, in a deductive method, that आप एक general understanding से आप एक particular understanding पे आते हैं. Let me give you an example here. What do I mean with this? Let's say we take the example of non-refoulement, right? It is the part of international law where it is suggested that अगर कोई एक शरणार्थी रिफ्यूजी अगर आपके देश में आता है तो आप उसे वापस नहीं भेज सकते हैं उसके देश में. Although there are multiple discretion which is there with the you can say the country for that matter to frame laws in this regard, but ये आपकी non-refoulement की जो you can say principle है, ये बोलता है that you cannot send back those people. Why? Because they might have you can say a fear of persecution. उन्हें मारे जाने का खतरा है, जैसे हमने देखा अपने recent रोहिंग्यास के साथ, या बहुत सारे हैं राइट, अहमदिया मुस्लिम्स के साथ, या उगर्स मुस्लिम इन द चाइना के साथ, बहुत सारी चीजें हैं. साउथ अफ्रीका में परसिक्यूशंस हो रहे हैं. तो दिस प्रिंसिपल सजेस्ट दैट, राइट. तो अब ये डिडक्टिव मेथड में अगर हमें यूज करना है तो वी हैव टू जस्ट पुट इन आवर आर्ग्यूमेंट्स दिस, इसे हम एक सब इशू बना सकते हैं, दैट the principle of non-refoulement is applicable in this case. All right, ये आपने सब इशू बनाया उस इशू के अंदर. ये एक जनरल स्टेटमेंट है. अगेन, ऑल राइट, सो अगर ये जनरल स्टेटमेंट है, अगर हम इसे डिडक्टिव मेथड के तरीके से यूज करते हैं, देन फ्रॉम जनरल वी आर सपोज टू मूव ऑन टू द स्पेसिफिक, मीनिंग देयर बाय अब ये प्रिंसिपल कैसे हमारे फैक्ट पे एप्लीकेबल है, कैसे इस पर्टिकुलर केस में अप्लाई हो रहा है, that is the idea which you would get from moving from the general to a specific thing. You are supposed to apply that principle to the factual matrix which has been given to you. All right. So that is the deductive method you are supposed to use. Now, this argument advanced also gives a particular understanding that you have backing reasons for that. You have reasons to suggest or to ask those reliefs from the court with legal clarity. Meaning thereby, let's say आपने वो cases cite करे, यहाँ पे आपको क्वालिटी और क्वांटिटी में फर्क समझना होगा. आप जो केसेस साइट कर रहे हैं, there is no golden rule, or you can say there is no golden number which will say that, if you have written this many cases, then definitely you're going to win. Let me tell you, you are mistaken with that. The quality is something which is supreme than the quantity. But 50 cases hone is not a good thing, but at least having those cases which are not overruled, which are not having, which are having, you can say, this बाइंडिंग इफेक्ट, वो सारे केसेस आपको लाने हैं. आपको देखना होगा दैट यू हैव टू डू एक्सटेंसिव रिसर्च दैट दीज लॉ, क्या ये केस जो मैं साइट कर रहा हूं या कर रही हूं, वेदर इट हैज बीन ओवररूल्ड. मेकिंग सेंस? ये आपको स्टडी करनी होगी दैट अगर वो ओवररूल हो चुका है, देन यू आर नॉट सपोज्ड टू राइट इट. सो हैविंग few cases good, but at least you should be writing those cases which are relevant enough, which are upon which you have a clarity. So again, if at all you have certain questions in your mind that फिर भी अगर हमें एक नंबर देखना हो कि कितने केसेस हमारे लिए इनफ हैं या होते हैं. So what I believe, being my personal opinion and being like judging certain you can say memorials for that matter, what I see is if the memorial has 35 plus cases or authorities, I consider it a good standard for that matter. So yes, meaning thereby अगर आपके पास तीन issues हैं, that remains in general, आपके 3 issues होते हैं. So 10 से 12 केसेस आपने एक इश्यूज में मिनिमम लिखे हैं, तो ये आपको 35 नंबर अचीव करने में आपकी मदद कर देता है. इट इज नॉट अ बिग नंबर. सो 35 प्लस इज समथिंग व्हिच इज गुड स्टैंडर्ड. All right. Moving ahead, that in the last part of your memorial, you would find prayer, the prayer clause for that matter. Again, if you would ask the same question here, that whether do we have any specific pages or a specific number of pages stipulated, so yes, your answer to that question would be प्रेयर क्लॉज हमारा एक पेज से ज्यादा एक्सीड नहीं कर सकता है और करना भी नहीं चाहिए. एंड इट शुड नॉट बी इन अ पैराग्राफ वाइज. आपने 4-5 लाइनें लिख दी एक एक प्रेयर में हर एक रिलीफ के लिए, दैट वोंट बी गुड. That won't be a good impression given to you, or fetching you certain points for that matter. आपको क्लैरिटी के साथ 2-3 लाइन्स में एक आपकी प्रेयर क्लॉज में लिखना होता है. एंड अगेन एट द लास्ट यू आर सपोज्ड टू in the prayer clause you are supposed to write that over and above the law. Let's say आपने ये प्रेयर में लिखा दैट हमारे पास आर्टिकल 21 का एक पार्ट है प्राइवेसी. ये पर्टिकुलर लॉ जो भी सरकार ने बनाया है जिसमें कि हमारी पर्सनल डेटाज लिए जा रहे हैं, राइट, इट इज डेरोगेटिव, राइट, ये उल्लंघन कर रहा है हमारे प्राइवेसी के राइट का, वगैरह वगैरह. और भी जितने भी आपके इश्यूज हैं वो आपने एक लाइन में लिखा. और आपको क्या रिलीफ चाहिए वो आपने लिखा, ये आपने लिखा. लेकिन ये भी हो सकता है, व्हाई टू मिस आउट ऑन एनीथिंग, राइट. अगर इसके अलावा भी आपको कोई एक रिलीफ मिल सकती है, then you are supposed to write a single line that any other order can be passed, right, in the light of the whatever has been stated above, in the light of equity, good conscience, right, and justice for that matter. Meaning thereby अगर law नहीं दी गई है, let's say आपको compensatory remedies नहीं दी गई है law में, हो सकता है जज आपको या हो सकता है कोर्ट आपको वो चीजें ग्रांट कर दे. और वो तभी करेगा जब आपने ये वाली चीज भी प्लीड की है दैट अगर कुछ और भी इक्विटी के थ्रू हमें मिल सकता है तो आप वो दे दें. लेट मी टेल यू हियर That again reminds me of one of the provision of law that is under section 21 of SRA, that is Specific Relief Act. It says that um, uh, it gives the court a particular power to grant compensation to the party. Compensation meaning thereby the damages, meaning thereby the monetary concerns. आपको कोर्ट के पास ये पावर होता है आर्टिकल 21 में दैट ये किसी पार्टी को compensation दे दे. When you will read that particular bare provision of section 21 of SRA, that is Specific Relief Act, you will understand that it clearly suggests that the court will only and only grant you compensation when you have claimed for it. So again, आपको किसी भी प्रेयर में किसी भी रिलीफ के लिए आपको मिस आउट नहीं करना है. यू आर सपोज टू राइट इट क्लियरली with all the like taking the law into the consonants for that matter. वो सारी चीजें आपको लिखनी होती हैं. And that's how we definitely develop this particular memorial from you can say a scratch to this prayer clause. That is the whole journey to it. So I would say that this webinar, of course, suggests you an idea from arguments to memorial, how you are supposed to bridge that particular gap, right? ये किस तरीके से आपको ये जो दो स्टांस हैं, that is arguments, that is the memorial on the other hand, ये किस तरीके से ये bridge करता है gap. I hope this will definitely help you in further making a particular memorial for that matter. Okay, so on to the presenter. I guess we have a question in the chat box. So if it would be good if they can definitely unmute themselves and they can ask the question.
Good evening, sir. Sir, I just wanted to ask that if we are supposed to make the memorial for both the parties, then can we keep the statement of facts same for both the memorials, or do we need to shape it a little according to the party which the memo is being made for?
Okay. So very good question here. Again, see, when we talk about the facts, right, you're not supposed to play with the fact, meaning thereby you're not supposed to write something extra which is out of it, right? While presenting, that is something other thing, but at least in the statement of fact, you are supposed to write the same thing. So yes, there is no guardrail for that matter, that something is right or something is wrong. ऐसा कुछ भी नहीं है. There is no gray area. Either it can be black or either it can be white, right? So you are supposed to write the same thing. Of course, you can do it. And if you find that something extra or some other fact which you have, which you are missing it out in the petitioner's, you can say arguments or the petitioner's memorial, वो आप लिखना चाहते हैं, बिल्कुल लिख सकते हैं. If you think that will be fine with you. But yes, important चीजें बिल्कुल हमें लिखनी है. Important चीजें छोड़ देना is not a good thing. It will give an impression in the mind of the readers or the judge that you only take up those things where which becomes helpful for you. You are not having that legal acumen to fight for it. You are not having that acumen to convince the court in that regard with the help of certain research which you can do. Getting it? अगर आप अपने रिसर्च से उस पॉइंट को सॉल्व कर सकते हैं जो आपने फैक्ट में लिखा है, ऑल्दो वो चीजें आपके फेवर में नहीं है, then definitely it will be a great point for you to win those brownie points for that matter.
All right, thank you, sir.
Okay.
गुड इवनिंग सर.
Good evening. Yes, please.
सर ये मतलब दो क्वेश्चन बहुत शॉर्ट में है सर. एक कि मूट कोर्ट की कौन सी स्किल जो है सर जो डायरेक्टली कोर्ट रूम एडवोकेसी में काम आती है, और सर कौन सी जो है वो सिर्फ एकेडमिक में रह जाती है. और सर एक क्वेश्चन ये कि जज जब हाइपोथेटिकल क्वेश्चन पूछते हैं जो रिकॉर्ड के बाहर हो, उस सिचुएशन में सर बेस्ट एडवोकेसी अप्रोच क्या होनी चाहिए सर?
Okay, so yes, okay, we'll answer this particular question, and then we'll move on to Ankita's question, which I can see. So, answering your question here, that एक एकेडमिक में रह जाने की चीजें और कोर्ट में सीखने की चीजें, बिल्कुल देखिए, जैसा मैंने आपको बोला और ये बताया, दैट एक मूट कोर्ट आपको एक आपकी जो नॉलेज है अबाउट द लॉ और उसकी एप्लीकेशन में, दोनों में मदद करता है। दैट ब्रिजेस द गैप, कि आपने जो अभी तक समझा है लॉ स्कूल में, वो किस तरीके से एक कोर्ट में आप अप्लाई करने वाले हैं, वो आपको ये समझाता है। ऑल्दो लेट मी टेल यू, ऑल्दो दिस डिफर्स, राइट। बहुत सारी चीजें आप देखेंगे दैट कोर्ट में जो हो रही हैं वो आपने मूट कोर्ट में देखा ना हो। बहुत सारी चीजें होती हैं, जैसे कि आप सिंपल सी बात ले लीजिए, एक ही दिन में मूट कोर्ट में पूरी की पूरी जजमेंट सुना दी जाती है, या जो भी पार्टी जीती है या कौन सी पार्टी हारी है, सारी चीजें वो आप रियल लाइफ कोर्ट्स में नहीं देखेंगे। adjournments नहीं देखेंगे, जैसे कि that gives an idea that this order 17 of the CPC says that आपको 3 adjournments मिल सकते हैं, right? और ये लॉ तो ये कहता है, लेकिन आप रियल लाइफ कोर्ट में जाएंगे तो आपने देखा होगा दैट मल्टीपल adjournments मिल रही हैं। बहुत सारी चीजें होती हैं which depends upon the discretion of a particular court, right? तो लेकिन सो ये तो बात हो गई आपके फर्स्ट क्वेश्चन के फर्स्ट पार्ट, दैट वेदर इट इज डिफरेंट, ऑफ कोर्स इट डिफर्स। और ये किस तरीके से हेल्प करता है? सो इट गिव्स यू फर्स्ट द लीगल अंडरस्टैंडिंग, द नुआंसेस ऑफ लॉ फॉर दैट मैटर, उसके लॉ में आपकी अंडरस्टैंडिंग बढ़ाने में मदद करता है। इट ऑल्सो गिव्स यू एन आइडिया दैट यू नो लाइक हाउ टू अप्रोच a particular law for that matter, or argument for that matter, right? आप किस तरीके से इस लॉ के लिए अप्रोच रख सकते हैं। अपार्ट फ्रॉम दैट, इट ऑल्सो गिव्स यू यू कैन से कॉन्फिडेंस इन द केसेस ऑफ पब्लिक स्पीकिंग। आप पब्लिक स्पीकिंग में आप बोल सकते हैं व्हेन यू कैन स्टैंड इन फ्रंट ऑफ द कोर्ट, लेट्स से द हाई कोर्ट, सुप्रीम कोर्ट, यू नो लाइक हायर इन पर्टिकुलर अथॉरिटी फॉर दैट मैटर, वहां पे आप बोल सकते हैं, तो बिल्कुल आपकी पब्लिक स्पीकिंग एनहांस होती है, राइट? और किस तरीके से आप एक अच्छा बना सकते हैं, तो देखिए, आपके मेमोरियल प्रेजेंटेबल होनी चाहिए। इट शुड नॉट बी लाइक यू आर डूइंग द टास्क एंड कंप्लीटिंग इट, नो, इट शुड नॉट बी लाइक दैट। फिर ये दूसरे मेमोरियल से आपको डिस्टिंक्ट नहीं बनाएगा। अगर आपके अपने मेमोरियल को डिस्टिंक्ट बनाना है तो आपके अपने प्रेजेंटेशन स्किल अच्छी रखनी होगी, आपको फॉर्मेटिंग अच्छी करनी होगी। आप मीनिंग देयर बाय, आप जब वर्ड डॉक्यूमेंट में MS वर्ड में लिख रहे हैं तो उसकी फॉर्मेटिंग सही से करें, सारे वर्ड्स पे जस्टिफाइड करें। जस्टिफाइड मीनिंग देयर बाय एक लाइन से सारे के सारे पैराग्राफ्स लिखे जा रहे हैं, 7-8 लाइन के बाद आप पैराग्राफ कर रहे हैं, हर एक पैराग्राफ को आप नंबरिंग दे रहे हैं, राइट? और आप फॉन्ट साइज सेम रख रहे हैं, दैट इज जनरली 12, राइट? एंड फॉन्ट स्टाइल आपका टाइम्स न्यू रोमन होना चाहिए। आपकी जो you can say this footnoting होती है, that should also align जो भी आपके you can say organizing committee दे रही है, let's say ऑक्सफोर्ड हो गया, let's say ऑस्कोला हो गया, right? और किसी भी तरीके का आपका हो गया, आपके citation style, वो आपको adhere करना होता है। जैसे मैंने बताया, थोड़ा आप अगर कहीं भी आप फैक्ट की बात कर रहे हैं, you're writing the fact which is given in the proposition for that matter, आप उसको वहां पे ब्रैकेट में आप लिख दीजिए। यू शुड ऑल्सो बी प्रेजेंटेबल, मीनिंग देयर बाय आपको एक कर्टियस होना होता है फॉर एवरी पॉइंट व्हेन यू आर आस्किंग द परमिशन। आप हर एक चीज के लिए कोर्ट से अच्छे से परमिशन ले रहे हैं, उनकी बातों को सुन रहे हैं। सी, यू कैन ओनली बी अ गुड स्पीकर व्हेन यू विल बी अ गुड लिसनर। सो इफ यू आर लिसनिंग राइटफुली, ये सारी छोटी से छोटी चीजें, मैनरिज्म, एटिकेट्स, योर ड्रेसिंग सेंस, योर ड्रेसिंग स्टाइल, आपके शूज से लेके आपके हेयर से लेके आपकी क्लोथ्स, एवरीथिंग मैटर्स। हाउ यू सिट, हाउ यू एड्रेस अ पर्टिकुलर बेंच, राइट? सारी चीजें मैटर करती हैं। सो इट इज ओवरऑल डेवलपमेंट। यस, प्लीज we can move ahead with the other question. I hope Ankita has.
Hi, sir. Good evening.
Good evening. Good evening.
So my question will be, what are the essentials which we need to keep in mind while we will be forming our oral argument?
Okay. So see, like of course, when we talk about the oral arguments for that matter, we have the guardrail in front of us. That is the memorial, right? Let's say multiple times you would see that if we are, exceeding what we have written in the memorial, that will not fetch us mark. That will eventually lead us to losing on the marks. So if at all you have missed out on something, let's say there is a guideline, or you can say a deadline for that matter, which has been given to you, that आपको memorial इतने time तक submit करना है, and you have submitted it. Now you are finding yourself that there are certain points which you have missed out on. तो आप उस चीज की printouts लें. You can take out the printout, like the first page where the citation has been given, the second, third page. जिस भी page में आपको उस particular judgment के paragraphs आप cite करने वाले हैं या बोलने वाले हैं, उसे आप you can underline it, right, with the help of the highlighters or something. और उस judgment का last page जो हम जहाँ पे कोर्ट के सिग्नेचर्स होते हैं बेंच के, वो आप ले लें. ट्राई टू मेक अ कंपेंडियम फॉर दैट मैटर. व्हाटएवर यू हैव रिटन, सारी चीजें बैक्ड अप होनी चाहिए, आपके पास रिटन प्रूफ होना चाहिए. वो आप कर रहे हैं, प्रेजेंटेबल बनाइए अपने आप को, मीनिंग देयर बाय यू शुड बी courteous enough, right? Again, one more thing should be there, like क्या आपको एक गुड लिसनर और किस तरीके से आपको एक brownie points दिलाता है. That can be, let's say, petitioner has, let's say, said something, and let's say the court had asked the petitioner that what is the answer to this, whatever, like let's say the grilling session has been going on, so petitioner ने वो answer नहीं दिया. So now your turn as a respondent, let's say आप respondent है उस case में. So when the turn comes to you, all right, you can try to play smart. अगर वो same issues आपके पास आता है और let's say आपको लग रहा है कि ये point पे बोल देना चाहिए, तो you should say that quote, right? Say that to the court directly by taking the permission that my lord, or however you are addressing the court for that matter. उनसे permission ले लें, and you can answer that particular thing. That, of course, like in this case, which my learned friend has missed out on, this has been held in this particular case, and that's what my submission is. So that will suggest, why would you do that? It is not like you are playing over smart there, but it will suggest the court that you are a good listener. You are listening to each and everything. अगर आपकी खुद की टीम से भी कुछ questions हो रहे हैं, let's say the speaker one is answering something and being grilled by the judge, and one or two questions or couple of questions they are not able to answer. So it should be the duty, the holy duty of the other person, that is the speaker, to when he or she comes up to the podium to suggest it or to argue in front of the court, before moving further with their issues or the submissions, they should be answering that. That will suggest that there is a team play in it, right? ये आपको एक show करेगा that you are playing in a team. It is not like आपने गलत करा and the other party is mocking it. Your other own team member is mocking, okay, fine, you couldn't answer the simple question or like that, isn't it? Because at the end of the day, you are winning together or losing together. That should be the idea.
Thank you, sir.
Any other query or?
Thank you so much, sir, for
Yes.
such an insightful practical session. Your guidance on mooting from research to advocacy has given us a much clearer understanding of what truly matters in moot court practice. We really appreciate you taking out the time to mentor and inspire aspiring legal professionals. But before we conclude, we would now like to open the floor for a short question-answer discussion. And we have already received a few questions from our participants. And with your permission, sir, I would like to begin with those.
Sure.
Okay, sir. So the first question is, what research strategy helps in becoming the best researcher?
Okay. So, okay, that's a very good question here. See, in multiple, you can say competitions, you would find that they have the best researcher award as well, where the researcher has to go and you can say answer certain questions, which are basically sometimes you would find it in an oral way, right? The questions are posed upon you and you are supposed to answer it then and there. Or many a times you would also find that it is in the MCQ format. So what kind of questions and how you're going to win that? So answer that, I would say you are supposed to be, first of all, be thorough with the facts. Every nuances, right? Every intricate detail you should be remembering, meaning thereby what are the dates for that matter, what are the timelines for that matter. Again, the other thing which comes into play is what our all laws are concerned. Let's say when we talk about the same example of the privacy being the fundamental right, the recent development like the DPDP Act we have, the recent development in the international forums, right? What all conventions are being brought up, what all treaties are being brought up, isn't it? So let's say taking the privacy thing again further, आपको यूरोपियन यूनियंस के भी चीजें पढ़नी होंगी, मीनिंग देयर बाय जितनी भी लॉज आपके पेरिफेरीज में हैं वो सारी चीजें आपको पढ़ के जाना है, वो सारे फैक्ट्स आपको उसकी पढ़ के जानी है. दैट्स इट. Nothing more than that. It is not a GK or some other things. Only the fact and the law you are supposed to be well versed with.
Okay, sir. So the next question is how to prepare oral arguments from the memorial.
Oral arguments from the memorial. Okay, so I believe as we have discussed the same point in the arguments advanced for that matter, तो आपकी जो ओरल आर्ग्यूमेंट्स होगी वो आर्ग्यूमेंट एडवांस से ही आप निकाल के पढ़ सकते हैं, right? It is not like you're supposed to read everything like a book and from the copy for that matter. You have to have a eye contact. You are supposed to, you can say, have a conversation with the judges, isn't it? So meaning thereby you are supposed to converse with them, and that's how you're going to master it. And the you're supposed to be thorough with the cases, you're supposed to be thorough with the facts, what you are saying. You are supposed to bifurcate your issue and submissions into multiple sub issues. Let's say you have two issues and at hand, आपको एक इश्यूज को 5 और 4 सब इश्यूज में बांट देना है, दूसरे इश्यूज को भी सब इश्यूज में बांट देना है, and that's how you're supposed to you can say argue. आप सारे ओरल आर्गुमेंट्स आप उसी तरीके से लेंगे, और अगर आप उसे एक सिस्टमैटिक तरीके से मार्शल करके बताएंगे, of course it will be a good, throw a good impression on the judge or the listener.
Thank you so much, sir. So the next question is how should a speaker address the bench in a moot court?
Okay, and this has been, you can say, a very hot topic when it comes to the Supreme Court submissions for that matter. Multiple times you would see that, they rebuke certain, you can say, young lawyers for that matter, because they do not know the nuances and how to address them. So for that matter, I will like to tell you and throw some light upon the Bar Council rules. The Bar Council rules suggest that, my lord, your lordship, your honor, right? These all words are very much applied for that matter. But again, will tell you that, many of the judges or many of the court do not accept these words. Let's say when you would say my lord, your lordship, something like that, if they have personal, you can say, a problem with that. So they would just say that, as we have seen in the recent past, they would see that it is the relic of a, this Britishers era, that it is a colonial legacy word which is being used. So you may call the sir as well. So it depends upon court to court, or it depends upon the mood of the courts. So whenever you start, my suggestion would be, whenever you start with the arguments or your oral submission, you take the due permission of the courts. Let's say there are two lady judges and one, one male judge for that matter. So you can simply say, my lord, or you can ask the judge that should we say your lordship, your ladyship, my lord, right? Whichever suits, you can definitely move ahead with that. And just for the general understanding, your honor word is used generally in the subordinate courts, and you should, not be using your honor. Rather, you should be saying my lord, your lordship. That becomes easy for that matter. And when you move on to the international cases like in JSUP, right, Stetson, these kinds of moot, which is argued in front of the ICJ, that is International Court of Justice, there you use the word your excellencies, right? So yes.
Thank you so much, sir. Sir, so the next question is how to handle a hot bench versus a cold bench in moot courts.
Okay. So basically, what I can gather from this particular question is that heated arguments, right? Or you can say the grilling sessions might occur. So it reminds me of my mooting days as well. So there you are supposed to handle your particular stance. How you tackle it, that's what being asked to you. How, like the judges will try to break your flow by any means or every means for that matter. And that's when your advocacy skills, like enhances because you are thorough with the facts, again, because you are thorough with the law. Even if I stop you somewhere, again, I will continue my thing. So you have to tackle that thing with you can say grace, with elegance for that matter. How you can do it, again, the question arises. You can do it by multiple practices in front of each other. Like you are a team of three, तो आप अपने आर्ग्यूमेंट्स, अपने सबमिशन अपने टीममेट्स के साथ मल्टीपल टाइम्स कीजिए. Ask your friends to grill you like anything. All right. For that moment, ask them to become your enemy. That will be the you can say uh, you can a solution to it. You can tackle the hot or the cold bench, anything it can be.
Okay, thank you so much, sir. Sir, just two or three more questions.
Okay.
First one, how to overcome hesitation and fear of public speaking in moot courts.
All right. See, hesitation definitely is there. See, again, I would tell you, like, even taking my example in front of you, I would say that even it was one of my, you can say, the hardest of the fear for that matter. So, how you can overcome it? You can take part in anything and everything. Start taking part. You will do mistake. You will commit mistake. Like take it up in your mind that fine. Making mistake is something which is inevitable. I will do it, but at least taking part will make you like different from your own classmates or many other people who are not coming up for that. So one day you will commit mistake, you will learn it through, right? And of course in the coming competitions you will definitely overcome it. So start with baby steps, you can say. Try to speak, try to take part, and like present yourself in the classes in the law school. अगर आप बोलना शुरू करेंगे, definitely अगर आप कोई debate हो रही है, extempore है, any kind of competition, take part in that. All will enhance you.
Okay, thank you so much, sir. Sir, one last question from my side. Sir, since in some of the moot courts, the number of pages in the memorials are not mentioned. So,
Okay.
what should be the ideal number of pages in the memorial if the number of pages are not mentioned in the rule book?
All right. See, that from my understanding, I would say that becomes a rare scenario for that matter, because what we have to do, let's say if I'm organizing a particular moot court competition and I have to judge the memorial as well, of course, like best memorial award if I have to give, I have to scrutinize it from the perspective of, let's say, Turnitin or some other, like a place where I check the plagiarism as well. So let's say it won't be giving a good impression if the other memorials are of 20 pages, 10 pages, and the other, like I'm, you can say this declaring the winner for the 10 pages, and the 40 pages memorial is not declared winner. So of course that will bring a enmity or any kind of you can say unfairness in the mind of the other person. So to bring that clarity and to bring all the competitors on a same page, the organizing committee definitely puts up it. Although if they have not, right, they have did not mention the pages. So try to stick with 8-9 pages for let's say 7 to 9 pages is a standard thing where you can sum up one of the issues, and that's how you can multiply. Let's say there are 3 issues, so 7 into 3, that is 27, 29 pages of your argument should be there in the memorial for that matter.
Okay. Thank you so much, sir, for patiently addressing all the questions and sharing such valuable insights with us. Your experience, clarity, and practical advice have added immense value to this session, and will surely help students approach moot courts and with more confidence and direction. On behalf of ClassMax team, I would like to once again express our sincere gratitude to you for being with us today and guiding aspiring advocates. I would like to thank all the participants for their active involvement and thoughtful questions. We hope this session was helpful and informative for everyone. With this, we conclude today's session. Thank you all for joining, and we hope to see you again in future sessions. Thank you so much, sir. Thank you, everybody.
Thank you. Thank you for the opportunity as well, and wish you the best.
Thank you, sir.